So welcome back. This is Newsfile. It's your most authoritative news analysis show. My guest, Kweku Bakoe Sankuma, Joseph Pemka Dimdiok, and also Inusa Fuseini. Now, we're moving on, but too many of your messages, some of which I cannot avoid or ignore. This one from Kojo says that if Inusa is right about law and morality, then why is adultery not illegal? Isn't it more prevalent and injurious to society than homosexuality? So in the end, what are you saying, Kojo? There is this article too that I'm being referred to that was written in June 30, 2015, which suggests that the practice of homosexuality is more than we think, because it is being done in secret, and therefore it is important to know exactly what will be done by this country now and not in the future. Andrew Dansoa Henkra, the president of the Ghana Independent Broadcasters Association, this one is, I think, to ACE. He says that I can see ACE is struggling with the explicit words to do a good job, but today's discussion has been most educative and balanced by your panel arrangement so far. Good job and keep it up. Professor Jampo also sends me a question. I think he wanted to make a contribution. He thinks that he says your panelists aren't also being fair to Ghanaians. I wanted okay, you wanted to situate certain reactions on the stage in which we are now within the context of democratic progression. It's a theory that he would like to share. Okay, maybe production, please get to Professor Jampo. There's a point that he wants to bring to bear that may give us some perspective that we may be missing. And there are many more, but I'm sorry, we are unable to take the messages again. Let's now go to the Supreme Court of Ghana on Tuesday, was it, or Monday? And before the Supreme Court of Ghana was a situation which appeared to be a dilemma of sorts, but the Attorney General urged the Supreme Court not to listen to Woyome. It is because Woyome had gone to the African Court on Human and People's Rights and told the court that Ghana is abusing his human rights in relation to the 51 million that was said to have been, fraudulently procured, and therefore, in seeking to get it, we are abusing or violating his human rights. And the court said it had the right or the power and authority to look into that matter. But before it does so, it thinks it is only fair for Ghana to stop the processes that it is now embarking on to retrieve the money, pending the determination of the court in the African Human Rights Court. So he brought that to the court's attention, to the Attorney General's attention, and the Attorney General told the court that it was not supposed to be binding on the Supreme Court. And the Supreme Court said, yes, we have said that before, because that law in the first place has not been has not been domesticated in Ghana, so it cannot bind us. So unfortunately, the state will go ahead to look for Woyome's assets and get the money back. So there have been scholars who have written and said what Ghana has done spites the AU, and we may lose our strength to be able to speak in that forum, because we are supposed to respect it, we didn't respect it. So what exactly is going on? Let me start with the Deputy Attorney General. Your colleague was in court and said what he said, and the court agreed with him that they don't share their jurisdiction or power with any other courts in the first place.
Thank you very much, my brother. You see, I would like to first of all put it in perspective. And what is an outrage to us as a department is the fact that people are trying to take my brother on unnecessarily. And my brother didn't write that judgment.
Yes.
It was the panel of 5 justices of the Supreme Court who took the decision. He only persuaded them with the law. that when people seek to bastardize the Honorable Godfrey Dami, it surprises me so much. Because he went to articulate the law before the justices and they have held it. But you see, let me put this in perspective. First of all, we have problems even with the decision itself, and we will soon be applying to the court for review of his own decision. You see, when the
decision for the interim measures in favor of Woyome. Okay.
When the processes were filed, we filed our affidavit in opposition and statement of case. And some say it was not an ex parte application before the African Court on Human and People's Rights. It was on notice to us. It was not ex parte. So when we filed our submissions, we were expecting that they would have sent us a mail to fix a date for us to go and argue our case. Nothing of the sort happened. Then the eve of the decision of the Supreme Court, we got an email from them indicating that a decision had been taken. And if you look at the proceedings of the day, Woyome was represented, we were not. How did they get to know that the case was to be heard on that date when we were not served any notice by the court to that effect? That's one. Secondly, when we are writing a critique of what is happening, we should look at it within the perspective of the decision that was taken. And we should read carefully the points that were made to persuade the justices to do what they did. Now, if you read Article 129, 1 and 2, it's very clear that the Supreme Court of Ghana is the final court of appeal. They don't share that with any other court. That is without equivocation. Now, the argument that was put before the court was this. That, look, for example, if you look at the African Development Bank Immunities and Privileges Act of 1967, it was contingent on the ratification of the 1964 treaty. Now, if you look at that, then what we were saying was that after Parliament had ratified or given the go-ahead for us to have this particular thing as part of it, we needed to move a step further, okay, to incorporate it into municipal law. And incorporate it into municipal law by the enactment of an act that will absorb that, because we are a dualist state, as you are aware.
What does that mean, a dualist state, as against a monist state? What does that mean?
Well, I don't know whether we will have to go into a lecture as to
monism. Because you have mentioned it, it's good to educate.
First of all, I'll be happy to address. First of all, let me expatiate my point.
Okay.
I'll
don't worry, Ace will take care of that.
Very well. You see, as I indicated, if you look at it from that perspective, there was no tacit enactment of an act to give effect to that. There's no doubt about that. And of course, looking at the provisions of 1291 and 1292, it's very clear that the Supreme Court is the final court of arbiter in this particular country. Now, Samson, you may have read this case, the Republic versus High Court Accra ex parte Attorney General, the NML Capital Limited and the Republic of Argentina, 2013-2014, two Supreme Court of Ghana.
This case.
990.
The famous Argentine case.
Absolutely.
The guy is here in the studio.
He's here in the studio.
Okay, go ahead.
I mean, of course, that was our anchor in our argument before the court. And the court upheld it. So the fundamental questions we should be asked.
What does it say in that case?
You see, I mean, it's a repeat. I mean, just a repeat of what I had said earlier. The fact that it had to be incorporated into municipal law and etc. But there's something interesting, which all of us are getting oblivious of, and I would like to put that again in perspective and in very strong terms. You see, the writ or the matter that came to the Supreme Court, the substantive case that came to the Supreme Court leading to the judgment that we are now pursuing Woyome, was by an individual, a private citizen of Ghana,
yes,
namely Martin Amidu, against Woyome and then the other company. And the Supreme Court made that determination. And in that case, and strictly speaking, that would be an individual against another individual. In which case, the court will not even have jurisdiction to handle the matter. The African Court on Human and People's Rights will not have jurisdiction. So they went looking at the motion that was now before the court without looking at the substantive matter which led to the judgment, which would have caused the jurisdiction of the court against Spain.
So you are saying that in the original case, because the Attorney General was a defendant,
absolutely,
together with Woyome,
absolutely,
Woyome cannot go to the African court
and now
suing the Attorney General, who is the defendant in the matter.
Absolutely.
But you are the one pursuing the money.
Yeah, you see, the fact is this.
And you are the one in the process of pursuing the money. You are the one violating his human rights.
The substantive matter, the decision in the substantive matter is what is appealing, not the execution processes. Unless you want to confuse the public. He's challenging the decision of the Supreme Court itself in respect of the declaration.
That's what he's doing in the African court.
That's what he's challenging. But not the execution processes. If he's challenging the execution process, it will be thrown out. You see, but the reason why he's coming...
No, this is surprising to me, because I thought what is in the African court is a human rights aspect.
No. He's challenging the decision of the Supreme Court to make those determinations that they made, so that they will set aside the judgment. Really? Otherwise, if he goes there with only just the execution processes, and then at the end they say, oh, don't do execution, what does that mean? It doesn't mean anything. The judgment will still stand.
Okay.
So he is seeking to attack that. But you see, I am suspicious about all the happenings. And I think that we are living in a community of humans, and we are applying the rule of law in whatever circumstance we find ourselves. The trajectory of events I gave you, doesn't it surprise you that you have filed, Samson has filed a motion supported by an affidavit and a statement of case in a competent court, and then the other side files a statement of defense and a statement of case and an affidavit in opposition? It is on notice. It's not ex parte. Then on the eve of the Supreme Court sitting, the other court sits and transmits information that, look, the processes you are about to go through, stop it.
But you
and
know,
then with the greatest respect, hold it.
You know that our courts are allowed to determine your application without hearing you.
Absolutely.
Okay. Especially when you had already filed your statement of case.
But what I'm saying is that the court sat, and in the sitting of the court, the applicant was represented. The applicant was represented. If suo motu, and without both parties, the court had come to that determination, it's a different thing. But they had come to the determination in the presence of the applicant and in the absence of the defendant.
Could it be that you...
And there was no notice issued to us.
Maybe it had been issued, but it didn't get to you.
That's incredible. And even the coincidence is suspicious.
Okay.
That it happened on the eve of the Supreme Court's decision.
But more substantively, the point is that because the treaty was not domesticated...
Absolutely. That was the crux of our argument.
If it had been domesticated, it would have been binding.
Absolutely.
And you would have obeyed it.
It would have been binding. But again,
it was against you, not against the Supreme Court.
Absolutely. That's even where I was just about to go.
Continuing, not the Supreme Court.
That's where I was just about to proceed. You see, even after the Supreme Court decision and all that, I have heard commentary run by a person close to Woyome, his aide or so, saying that, even in this matter, it was the Attorney General who was asked to stay the processes, and that whatever the Supreme Court did, it was just the Attorney General that the court asked that stay the process.
Is that not the case?
But it was not directed at the Supreme Court. Is that not the case? It wasn't directed at the Supreme Court. If that was the case, why was the need for that motion they filed?
Which one?
The motion they filed that morning to arrest the decision of the Supreme Court.
Okay.
Very interesting.
Was it not just to bring to the attention of the Supreme Court that the court has said that you should hold it?
You see, I think, and rightly so, within my right, that in spite of what is happening, there's bad faith in this matter. And bad faith, in my candid opinion, and which is influencing, it can influence the decision of any court, is actuated by the fact that Woyome had actually agreed to make payments, and indeed made part payment. And upon the assumption of office of this particular government, the music changed and the dancing also changed.
He paid 4 million, right?
Yeah, that's the point. And you see, you are aware that this is not the first court he has taken us to in the international arena. You are aware, ICC, ECOWAS.
Yeah, he was thrown out.
Everywhere, he's taking us there.
Okay.
And as my uncle Kwekubago once said, people will soon sue God. That's unfortunate.
But just a brief one. And I was drawing attention to something about what is becoming known, that you may be engaged in double standards. Because you say the African Court Treaty is not domesticated in Ghana. That is why you will not respect it. But
Serious.
That is why it ought not be respected.
We have not said that we will not respect A or B. We have canvassed this before a competent court, constituted by a competent panel, and they've agreed with us. So it is a decision of the court, not the Attorney General.
It's a decision that you desired and you got.
Absolutely.
So that's what it is. Now, what do you say to those who say the very eve you were preparing and reading and getting ready to come and make this argument, the Attorney General's department was voluntarily submitting to pay 800,000 United States dollars on the back of a default judgment obtained by a Nigerian against Ghana in the ECOWAS Community Court, which Community Courts treaty also has not been domesticated, and which case the person tried to get the money 2006, came to Ghana's court. The Attorney General then went to court, used the same case you referred to that Sankma was involved in, and urged the court not to grant the payment. And the court said, on the basis of that case, Ghana should not pay. Suddenly, you have now gone and you are paying voluntarily without compulsion. That's double standards.
Samson, just a quick point. You know, even before we started the program, you talked to me about it off air.
Right.
And I was indicating to you that I do not have the details as it stands. And that, given the opportunity, I will cross-check from the office and furnish you with that. Because it doesn't fall within my area, as far as the office
the brief detail is that there's a Nigerian businessman, properly named, who came to Ghana, was building a multi-purpose ultra-modern building in Ghana, and Ioko or Ghana found that he was involved in money laundering, and so he got arrested. His bank accounts in Ghana were frozen. He jumped bail. He couldn't come back to Ghana, and he has gone to the Africa court. He went to the ECOWAS court, arguing that you have compelled him to sell that property cheaply, and you abuse his rights. And he got a default judgment, meaning you didn't appear in the court. He got a default judgment. He came to Ghana to enforce that judgment. You, the Attorney General Department, in 2016, went to court and said, on the basis of the case you referred to, the Argentine case, he should not be paid. You should not be compelled to pay. The court agreed with you as Ghana, don't pay. So you haven't paid. Suddenly, you know, in 2017, you wake up, and on the eve that you were going to the you were preparing to go to the Supreme Court to argue that on the basis of that same case, you should not be compelled to pay. You were voluntarily agreeing to pay $800,000.
Do you have that as a statement of fact, that there has been a voluntary submission and we have agreed to pay? Do you have it as a statement of fact?
Yes.
You have that as a statement of fact?
It's a statement of fact.
I think you have to cross-check that.
It's a statement of fact.
Be very certain beyond a shadow of doubt.
I'm certain about it.
We have made our argument, and we still stand by the arguments we made, which persuaded the Supreme Court in this direction.
Okay.
And which is what was replicated earlier, as you have stated. And this particular bit that you are talking about hasn't come to my attention.
Okay.
And I do not want to belabor the point.
The Attorney General has done so. Okay. Thank you. Okay. So, Ace, now, are there any implications for us? Did the Supreme Court do right, and did we also do right when we went to the Supreme Court? And on the basis of a case that we are told you were involved, we shouldn't obey.
It's a very difficult situation to
very interesting.
I've had the dubious honor of arguing the two different ends of the same principle.
Okay.
Anyway, let's deal with it. Now, let's start from brass tacks. One underlying principle of our constitutional order is the concept of separation of powers.
Oh,
there's the executive led by the president, and that's what they have to do in terms of running the country day to day. There's parliament, which is the representatives of the people who make laws, and then there's the judiciary who interpret the laws. Except where the constitution allows interplay between them, their offices are distinct. A president can never make law, and that was part of my position when there was the whole outcry about what the President Akufo-Addo said about the homosexual issues. He can't make law. he might be the president of Ghana. He has no power to make law. President Trump is finding that out, quite painfully.
He assents to the law. The president assents to the law.
He assents, but he can't make the law. His desire can never become law.
If he doesn't assent, it doesn't become law.
Where people like, that's part of the interplay. Right. That's part of the interplay. Where you meet people like,
but that's why there's even a substantial limitation on his power to refuse to assent.
Yes, if you refuse to assent, they can overwhelmingly assent it for him. Okay. So there's a checks and balances.
Okay.
Now, this lack of power of the executive led by the president to make law comes into sharp focus on the international plane. So Article 75 authorizes the president to enter into treaties, international treaties. But then, so the president can enter into any international treaty that he desires. He doesn't need parliament to approve it. But that treaty will not have the force of law in Ghana unless parliament has ratified it either by an act or by resolution. So there's the subsequent, the ex post facto parliamentary ratification, which will then give it the force of law in Ghana. So for example, the 1958 New York Arbitration Convention became part of our law when it was incorporated in the 1961 Arbitration Act, which incidentally we made part of our law even before we ratified international law, but that's another issue. So you have a dichotomy. And that's what I call the internationalists have to face all the time. Is international law really law? If it must be ratified by a municipal parliament before it has the force of law within a country. So there's always that balance. What applies in Ghana and what doesn't apply. Now, if the president can simply sign the international convention for it to have the force of law in Ghana, then the president is making law. And so that, what happens if the president signs a treaty that is against municipal law? That will drive horses and carriages through the principle of separation of powers. That is why Parliament must ratify before it has the force of law in Ghana. So that has to do with treaty law, where our Article 75 is clear. And especially when you are dealing with the jurisdiction of a court, you ought to be extra careful when you are bringing a decision of an international court or tribunal into play in Ghana. That is why if you have a foreign judgment, it must receive a stamp of approval of the Ghana court before you enforce it in Ghana. The foreign judgment will not have automatic force of law. It's just like an arbitral award. You must go to our high court and get them to register it. And even then, it's on the basis of, apart from arbitration, but judgment is the basis of reciprocity between Ghana and the other country. If the other country won't recognize our judgments, we won't recognize theirs as well. You have to file a fresh action in Ghana and depend on that judgment as proof of debt. And so there's always that interplay between public international law and even private international law and municipal law. Now, you're right. But there is, now let's make the difference between customary international law, what we may call jus cogens, the peremptory, fundamental, overriding principle of international law from which no derogation is allowed. They apply municipally, not because they're international law, but because they are considered a part of the common law, which Article 11 makes a part of our law. So the principles of customary international law are received in Ghana through the common law, and so indeed have the force of law in Ghana. International human rights treaties do provide Article 30-something, 34, 38, that they will apply in Ghana as well because they set international standards. So arguably, they are also applicable in Ghana without going through the parliamentary ratification process. But every other treaty that is entered into must have parliamentary approval. That was the dilemma Ghana faced in NML Capital. What was it? Some naughty lawyer, instructed by some other people, got an order detaining an Argentine war vessel in Ghana. The principle was whether Ghana could detain a war vessel. And so Argentina went to ITLOS. People of Ghana, this is not our first trip to ITLOS. Argentina went to ITLOS against Ghana. And the ITLOS tribunal gave an interim order that Ghana should release the vessel. Ghana argued that, well, it is our courts. We as the executive cannot control the courts. They still gave the order to Ghana to release it. How was Ghana going to release the vessel without a court order, when there's a valid court order in Ghana detaining it? So the Republic of Ghana instituted the prerogative proceedings in the Supreme Court for an order of certiorari, quashing the order of the High Court that detained the ship. Of course, by that time, we had allowed the ship to sail away, so the rest of it was academic, really. But we argued, it was a full-throated argument. Ghana argued that on the basis of the UN Convention of the Law of the Sea, there's a specific provision that forbade countries from detaining military vessels. This naughty lawyer on the other side said, wait a second, Ghana. Yes, there's a UN Convention of the Law of the Sea, applied worldwide. Ghana has ratified it, has acceded to it as international law. But guess what? You never got domestic ratification. That even though at the time you didn't have parliament, so to speak, there was a process through which you domesticated the law. And indeed, Ghana had domesticated an aspect of the UN Convention, the delimitations processes. But the Convention of the Law of the Sea itself had not been domesticated. And so the order of ITLOS should have no binding effect on the Supreme Court of Ghana. The Supreme Court of Ghana said yes. In fact, the Supreme Court was shocked that Ghana did not at the time appear to know that we had not done a domestic ratification of the UN Convention of the Law of the Sea. Guess what? We still haven't done it. And we have another ITLOS order. I'm not going to go there.
Wow.
Yes, we haven't done it.
Interesting.
Anyway, so I'm sorry, I never intended to say this in public. I don't know how it came out. Might be complete fault. So we were faced with that, and the Supreme Court said no. Although the Supreme Court found another reason to order the release of the vessel, which said we are making a new rule of public policy that because of the potential of war, if you seize a military vessel, Ghana, although we don't have statute that on that matter, we should have a principle of public policy which allows the said vessels not to be seized in Ghana. But there was an interesting interplay between international law and domestic. Now, this is the law, and this is the case. Interestingly, the government who fought us on this case has been relying on that case in other matters.
To win these cases
in other matters. That's very interesting. See, there's no morality at law. If there was, anyway. But you must always understand that your municipal law may not allow you to do it, but it can have international law ramifications. And so, in another matter, Balkan, Supreme Court says it's an international agreement which required parliamentary approval. An arbitral tribunal, and I can speak to it because, as far as I'm concerned, the Attorney General waived the right of confidentiality when they went public with the Balkan Arbitral Award. The arbitral body says, yes, you are right. It is an international transaction. And because it's an international transaction, at the international plane, we will read into it principles of public international law. Because it's an international transaction, your municipal law alone will not be enough. And so, although, yes, your constitution requires that you go for parliamentary approval, but if it is your fault that there was no parliamentary approval, we will not allow you to rely on that. So you can claim that there's no estoppel on constitutional principles, but there is an international law principle of estoppel which will hold you to pay.
So they called the bluff of the Supreme Court.
They were very respectful. They said we agree with their basis, but we disagree with their conclusion. They were very respectful.
I see.
And note, Ghana Supreme Court in that case never moved specifically proclaimed the agreement invalid. They stopped it and referred it to the High Court, and we never went back to the High Court. I was happy. Ghana never went back to the High Court for the final conclusion. The matter went to international arbitration. We all appeared, and that pronouncement was made. So there's a balance. So Ghana may decide now, and in fact, the Supreme Court will bristle with anger if you bring a decision of any foreign court and throw it before them and say, apply it. Now, you, Supreme Court,
So in other words, even in the absence of the domestication issue that we are talking about, if it had actually been domesticated, would the Supreme Court have said,
it is
okay, because of that,
it is still what the Supreme Court might do is to pay respect to the decision. There's that whole thing about judicial respect.
So they suspend the trial.
One can never tell where they'll go.
Look,
we have an activist Supreme Court. I think it's the most activist Supreme Court we've ever had in the history of this country. And so you can never predict how the Supreme Court is going to go. But at the very least, there ought to be domestication. So that's the point. We are entering into many international treaties which have not been domesticated. This problem is going to come up, and the court will not respect a treaty as long as it hasn't gone through our parliament. And even if it's gone through our parliament, can parliament limit the powers of the Supreme Court in breach of the Constitution? This is always an interplay between international law and
that's trouble.
So, well, it's trouble for every country in the world.
Interesting. But you see, as the argument went on, I went to read Article 18 of the Vienna Convention on the Law of Treaties. And it spoke about obligation not to defeat the object and purpose of a treaty prior to its entry into force. A state is obliged to refrain from acts which would defeat the objects and purposes of a treaty when it has signed the treaty or has exchanged instruments constituting the treaty subject to ratification, acceptance or approval until it has made its intention clear not to become a party to the treaty, or it has expressed its consent to be bound by the treaty pending the entry into force of the treaty and provided that such entry into force is not unduly delayed. So we are unduly delaying the processes of domesticating these laws, these treaties, and when it doesn't go for us, then we are against it.
I agree. We are absolutely in a position where we are cherry picking. Governments over the years cherry pick because they will not send these to Parliament, or Parliament might not pass them.
Okay.
So, but it will stop your obligations as international law.
Okay.
Fact. So we lost an arbitral award. We thought we won, but we lost, and they won't come to Ghana to enforce it. They will attach your properties outside Ghana.
Right.
So at the international plane, there could be ramifications. But domestically, our courts will not respect this because you have not gone through the process which will domesticate or municipalize the law. If we want all our treaties to be followed by our courts, we ought to domesticate them. But even then, we might get into constitutional issues.
Right.
Can you limit the power of the Supreme Court by any process?
Because of the suggestion, is it true or is it possible that when our president goes to the AU, he might not get the respect that ought to be accorded him because of what has happened? That is an AU court.
Well, respect. He just came from Cote d'Ivoire. Look, let's not stretch it. I can understand my international law friends. I mean, look, they've spent years studying international law. They're teaching international law. They must advocate the thing. And like I said, I'm in a dubious position where I've argued on both sides of the matter.
Thank you.
And look, it doesn't take anything from anybody. I actually think, look, I agree with the learned Deputy Attorney General that look, we are just this is a person who's lost a case. He's trying every opportunity available to him to get it done.
Kuku has a description for that. Let's wait when we get the Kuku
when you lost the judgment and you are paying, and I said it's a human rights issue.
Thank you.
In fact, the African Court should have asked itself whether it has power to even hear them.
Okay, thank you. It says it has power to hear it. Okay. Yes. Honorable of saying, let's hear you. What do you make of what is going on and the claim that this is going to cause or has caused international embarrassment to Ghana?
Seriously?
And that as we speak, we actually are putting up a candidate for the international court, and ECOWAS says we endorse your candidate, and they have asked President Akufo-Addo to go and tell the his friends in the African Union to also give their support to our candidate. And the suggestion is that he can't go there and do that because they will say you don't respect even our own processes. Yes.
Well, I think that the proponents of the view are confusing a lot of issues. The court that they went to came out of the African Peoples and African Peoples and Human Rights Court.
They had the protocol to it.
And that has to deal with the protection of the fundamental rights of persons of African descent. And so to go to that court, you have to assert that your rights have been violated in your country, and you've exhausted all the local remedies, and it appears that the state is bent on violating your rights, and so that's how the Nigerian won against Ghana. I mean, he went to court. The court refused him, and he was successful. He successfully argued in the court that Ghana had foreclosed his rights. There was no way he could enforce his rights, and so the only avenue left was the court, and that's why the court upheld the decision, and that's why they are seeking to pay. The Attorney General appeared several times. They couldn't succeed because the court clearly has said that they should freeze their property.
But the Ghanaian court ruled in favor of our Attorney General.
Yes, so he went to court to argue that the Ghanaian court the state had used the Ghanaian courts to violate his rights. That's what I mean. The Ghanaian courts were now a symbol of oppression by the state.
Okay.
So that's how he argued, and he succeeded. But ACE has spoken extensively about the investor-state dispute settlement regimes, which are evolved and which have found place in many partnership treaties that we have entered into, the EPA, many provisions of investor agreements that now contain such dispute settlement regimes. And that's why the court has insisted that when we enter into foreign treaties, not foreign treaties, investment treaties or agreements with foreign investors, we must ratify same in Parliament. And now the court, a lot of body of opinion is emerging from the courts, even to determine whether a company is foreign in nature or local in nature. And so yes, as we continue to evolve, we will be able to define exactly which companies should get that approval in our parliaments, and which companies do not need such
So
approvals.
no wrong has been done in
No
the
wrong has
Woyome
been done.
matter.
The Constitution is very clear. Article, and I had opportunity to say it when it was reported that he had gone to the African courts. He's added a lot of background to it. But the Constitution is very clear. Article 129. 2. Or is it 2 or
1291 and 2.
1292. Actually, I'm interested in 1292. It says that the Supreme Court shall not be bound to follow the decision of any other court. So whatever decision that emanates from any court anywhere is of persuasive authority.
When we go there and we sign the treaty, what are we trying to do?
That is why Martin Amidu is arguing.
Are we not surrendering part of our sovereignty?
That is why
back to
Martin
that?
Amidu is
The
arguing.
president can't do that. It's the executive signing a treaty. The court can say, we'll look at it.
Well, that's a treaty.
It's a
And
treaty.
that it can't surrender the judicial jurisdiction of the courts
Okay.
to an international body. The president cannot do that. He has no capacity to do
So
that.
these courts, regional courts, are useless.
No, they're not useless. They're not useless. They are meant to help develop a body of knowledge and standard of behavior in all countries that will promote certainty and
I tell you why I
predictability.
say they are useless. Doing my research for this show, I find that the ECOWAS Community Court, even Nigeria, where it is headquartered, does not respect its decisions.
Because of
In
persuasive authority.
Nigeria's courts have always, rubbish whatever comes out
Yes,
of
they
that
will have a
place.
look at it. They will have a look at the decision. But the decision must be in sync with public policy. It must be in sync with the laws of the country.
There
You
is no
can't just-
evidence that the member countries that have signed up to that treaty have complied with orders that come out of that court.
Even where we have not signed up to treaties and the decision is emanating from a common law jurisdiction, our courts are enjoined to have recourse
Okay.
to those decisions.
I see.
But those decisions remain persuasive in nature.
Okay.
And so the court, like he rightly said, the court refused to be persuaded by the decision. That's all. And this is this matter, with the greatest respect to Woyome, is of criminal nature. I mean, it's in criminal jurisdiction. It's territorial. I don't know how you can go to some other territory to say that we shouldn't pursue a criminal matter against a Ghanaian.
I think he's arguing on the enforcement.
see.
On the
Yes,
enforcement
yes,
of the judgment.
He's arguing on the enforcement of judgment. But the judgment,
He won the criminal matter. Is the enforcement of the Supreme Court decision against him to pay the monies to Ghana?
Right.
That he says violates his rights.
Right.
And he's argued this in the courts of Ghana. He's lost the point. He's gone to ICC everywhere. Look, this is his last chance.
Okay, Kwekubako describes this as some sort of irritation. Can we hear him now? But there's been some also uncertainty because there have been claims that, in fact, Ghana has done the parliamentary ratification of the African of the treaty, setting up the African courts, and so we are not being truthful when we say it has not received the appropriate domestication processes that it has to go through. Yes, Kweku.
Well, we can check with Parliament. Parliament should be able to. The records can be verified.
There's a suggestion that it was Joe Garte who led that process.
Okay, I'm not
If
aware.
they can
but
produce the
it-
ratification,
yes,
they should produce
it's a very
it.
simple thing. But listening to my friend, Deputy Attorney General's account, I'm beginning, and I don't have any other, it's just an instinctive thing. I'm beginning to think that the ruling from, is it Arusha, Tanzania?
Arusha.
Yeah, Arusha, might be of doubtful validity. I'm beginning to think so.
Yeah, because
See,
of the
the
narration
more-
he gave.
Yeah, how was it communicated to us?
It was emailed.
Really?
I have
To the court?
No, it
It's
was
not
emailed
to the
to our
court.
Attorney General,
To our
and then a
Attorney
motion filed to arrest the judgment. And
On the
this
basis
annexed-
of that-
On the basis of, and this annexed to the motion.
Absolutely.
I have my doubts. I think we need more clarification.
Okay, you are suggesting that Woyome compromise all of those judges there in the African court?
Not at all. I have just given the bare facts as they are.
But that's what
for
your
the
comment
public to
suggests.
judge.
Okay.
Yes, I have given the facts as they are.
His submission reinforces that instinctive thing that I have. I think there's something missing. We need to double check with the court how the processes were dealt with and what kind of ruling they gave. I mean, I'm a bit surprised that it had to take Woyome and his people to...
That's what the ruling, we have all seen it.
Yeah, to communicate it. And what effect did they think it was going to have in the courts, you know? But as I'm saying, I'm relaxed about this Woyome thing. It's been long, so it's frustrating, you know, and there's a lot of anger out there in terms of our failure to conclude, bring this matter to a closure. And that's the only reason why I described it as a transient irritation. It's something that he would not win, even at that court, even in Arusha, he will lose. So I'm really thinking that we shouldn't unduly overwork ourselves as a nation and as a people. Time. We've wasted enough time already. So why can't we wait a little while to get this matter settled finally? Right within Ghana, we should continue to pursue the recovery efforts. That's what we should do. And I'm beginning to think that those who helped, those who facilitated this thing, perhaps we haven't taken a serious look at them. Those political appointees, the government functionaries who allowed this thing to happen. It's about time. I'm not a lawyer. I don't understand how the legal processes will go. But unless I'm told and convinced by law that it's a closure, even on those who played a role, we will see visible, tangible evidence that people who we had entrusted some responsibility to just failed to help the nation.
Or refused.
Or refused. Are they okay? Does the law exclude any action? Is there a statute limitation on what to do about those people? And we know who we are talking about. Some of them even got elevated subsequent to the roles they played. One of them was made the first deputy speaker of parliament by our friends. Are we leaving them alone? I think that we should take another look at that aspect.
Well, it does appear that there's no liability for giving a legal advice in that office. So if you are pointing to the former Deputy Attorney General, Ebobati Nodro, he gave...
But the facts go beyond that.
The facts go beyond that.
You think so?
The letters, the advice, the letters he wrote to the president, the arguments he had with the finance minister.
I was sitting in this seat when we
What are we talking about?
If you remember. And we had the first judgment of the High Court in our hands. And that judgment was literally crying out, give me more. That you did not give me enough to convict these people. And the day when we begin to talk about the Special Prosecutor's Office, I will cite that judgment as the reason why we need a special office to prosecute white-collar crime.
Okay.
Look, the judge was literally crying. Where are the other people? They were not even called as witnesses.
Yes.
Because there was a leaked memo from the Attorney General's Department. A memo which should have gotten legal privilege. It should have received privilege. Was leaked and tendered in evidence without objection, stating that the department itself was at odds with itself.
But you forget that judgment was appealed at the Court of Appeal.
And it succeeded.
And the Court of Appeal had different opinion to share.
Yeah, but ultimately it upheld the lack of conviction.
Okay.
But he was crying, I need more. And the judge was not giving enough.
Okay.
And proof must be beyond reasonable doubt.
Yes, and let's not forget, even the Supreme Court, in its bringing the case to conclusion, looked at the performance, the conduct, the lawyers and the state attorneys, Attorney General.
Yeah, some were directly recommended to be sent to the General Legal Council.
We should. What has happened to all those things, all those missing links?
Okay. Interesting. Yeah. But before we take a break, just 30 seconds, Honorable Minister of Seni, what do you say about Article 40, and I'm looking at 40, particularly 40C, which says that in its dealings with other nations, the government shall promote respect for international law, treaty obligations,
Yes.
So when you say you
the
sign
law is
these
not saying
things,
that the government shall or the government shall promote respect. Government shall promote respect. And I think government, you are using government narrowly in terms of
that
the definition
it says that
296.
it says that it shall adhere to the principles enshrined in, or, as the case may be, the aims and ideals of one, the Charter of the United Nations. Then it comes to the Charter of the Organization of African Unity, which is now AU.
Yes.
And then it comes to ECOWAS.
Yes.
Yeah, but having said that, you can't read 40 in isolation. You must read 75. That if you want the Supreme Court of Ghana, I mean, to stay its execution processes, you must produce more than the treaty you have signed and not domesticated.
Okay. We take a break. When we return, we go to Libya and see if we can assist to bring some Ghanaians home. We'll be right back.